have one moment? Okay, based on your experience, sir, and training, in your opinion, was the murder of Ron Goldman and Nicole Brown a drug-related murder?
No.
What's wrong with the form of that question?
Yeah, without the reporter. All right, the objection's withdrawn?
Yes, sir.
All right. Ms. Clark.
Based on your experience and training, sir, in your opinion, were the murders of Ron Goldman and Nicole Brown drug-related murders?
I do not believe they were.
Please tell us why.
It's been my experience that the vast majority of drug-related murders are carried out with a handgun or a firearm of some type. It's also been my experience that usually there will be evidence of narcotics usage or sales at the location, such as scales or debris from narcotics, something to indicate the sales or use of narcotics. It's also been my experience that when a residence...
Hold on, sir. Did you find any evidence of drug usage or sales at 875 South Bundy?
No.
Go ahead, I'm sorry.
It's also been my experience in the murders that I've handled that the location, if open, will generally be ransacked because the victims are many times known to the suspects, and the suspects will ransack looking for information that might implicate themselves, such as their names, their phone numbers, telephone books, things of this nature. And also many narcotics murders, murderers will take money, drugs, weapons, or anything else that's available. It's also been my experience in drug-related murders that they're generally not committed in an area where it would be observed by the public. It would be in a secluded area or in a closed area. And the suspects are generally going to pick the time and location on their own. It's not going to be in an open area like this.
And so you found none of those indicators in this case?
That's correct.
Let me ask you, was the blood of Ron Goldman and Nicole Brown tested for toxicology to determine whether or not there were drugs present in their blood?
Yes.
And are you aware of the results of that testing?
Are you aware of the results, yes or no?
Yes.
Next question.
Did those results cause you to conclude that there were drugs involved in this case?
That is hearsay. Result is,
But
it's a result, assuming a result.
it is.
We're assuming facts, not in evidence.
When you learned of the results, sir, of the toxicology, what, if anything, did you do to pursue the line of inquiry as to whether or not these were drug-related murders?
Call roll.
Nothing.
Now, when you, in general, sir, when you investigate any homicide, do you consider all possibilities in terms of the motivation or why the murders occurred?
Call roll.
Certainly.
Okay. Did you do so in this case?
Yes.
And when you do that, and you did so in this case, what causes you to focus in any one direction?
Generally evidence or certain factors that may arise that point in one direction or another.
And did you follow the evidence to lead you to a particular theory in this case?
Yes.
And what is your theory of this case?
The theory of this case is that
Sustained. Sustained.
I thought that's what he asked about on cross-examination, Your Honor.
Well, with the reporter, please. All right, thank you, counsel. Ms. Clark.
Sir, without giving us your opinion as to the guilt or innocence of the defendant before the court now, did you formulate a theory as to whether or not this murder was perpetrated by one or two people?
yes,
And what was that theory, sir?
that was perpetrated by one person.
And what is that based on?
I observed one distinct set of bloody shoe prints between both victims, leading away from both victims west on the sidewalk, away from the location. Both victims were killed in a similar manner, slashing and stabbing wounds. Both victims had their throats slashed. I observed a drop of blood on the sole of the boot of Mr. Goldman. It contained a mixture of blood from both victims, indicating to me a cast-off. Indicating to me a cast-off of blood from one murder weapon.
Did you see anything to indicate to you, sir, that the perpetrator moved between the two victims?
Yes,
And what was that?
the bloody shoe prints, same distinct pattern that I observed going away from the location.
This next photograph you mark People's Exhibit number 98. You want to make this next photograph be marked People's 98.
Yes.
And I recommend that you cut the food.
Thank you.
Could you please?
What's shown in this, this is People's 98? What is shown in this photograph, sir?
It's the sole portion of the bottom of the right foot of Mr. Goldman.
And can you describe for us, sir, where in this photograph you saw drops that appeared to be blood?
There are drops.
Oral.
There are drops of blood here, but this is not the one that I alluded to.
Okay. Next.
You want to make this next photograph be marked People's 99.
All right, People's 99.
And before you do, Jonathan, hold on. Where is Mr. Goldman being shown here?
This is on the walkway in front of the location.
Okay. And whose hand is holding the boot up?
Appear to be the coroner's assistant.
And who's standing in the background? You see someone standing
Appears to
wearing...
be the coroner's investigator.
Claudine Ratcliffe?
Yes.
Okay.
People's 99. And your art is the Uncut.
Yes, it is.
Okay. Now, is this... tell us what this photograph shows.
This shows the bottom of the boot to the left foot of Mr. Goldman.
Okay. And do you see in that photograph the blood drop, the mixture of blood that you referred to?
Yes.
And where is it?
They're in the center, in the white portion. It's not muddied.
Mm-hmm. Now, what does the existence of a blood drop like that in the sole of the shoe indicate to you?
It indicates to me that that mixture of blood is probably a cast-off from a weapon, as the weapon was being slashed or moved in some manner, that droplet was somehow slung off of the weapon.
And what does it tell you about the position of Mr. Goldman at the time that the blood was dripped onto the sole of the shoe?
It tells me that
One minute question. Cause for speculation also.
You have phrased the question.
Did you form an opinion concerning the manner in which the position in which Mr. Goldman was when the blood was dripped onto the sole of the shoe?
yes,
And what was that?
he was down.
Now, sir, I think you indicated that after the body of Ron Goldman was removed from the location in which you observed it, where it was found in that small dirt area, you observed something that had been underneath his body? Do you
Yes.
recall that? And what was it that you observed, sir?
A ring.
Your Honor, I have here a manila envelope which currently bears seals. I'm going to ask that the detective break the seal and describe what he's doing. Sir, I'm showing you an envelope, a manila envelope, which is marked, imprinted with the title Analyzed Evidence. Do you recognize this envelope, sir?
Yes. It's an LAPD analyzed evidence envelope, item number 40.
And what is item number 40 in this case, sir?
The ring.
The ring?
Yes.
Is it currently sealed, sir?
Yes.
Could you please open the seal?
Yes. Taking his scissors, cutting across the top of the manila envelope, breaking the seal. Opening the envelope. Moving a small coin envelope.
And is the small coin envelope sealed, sir?
Yes.
Okay, could you please open that seal?
There are two packages. One is labeled scrapings from ring. Moving that from the top, I'll put that aside.
Okay, was that small package entitled Scrapings from the Ring, is that sealed separately?
Yes.
And you've removed it from the front of the envelope, the small manila coin envelope?
Yes. Now cutting the top of the small manila envelope with the scissors. Opening the envelope.
Okay, can you tell us if you recognize what you see inside?
Yes, that appears to be the ring that I observed at the crime scene.
You want to mark the envelope and contents, People's 100?
100. I wonder if the detective could step down and show the jury the ring by holding it on top of the envelope in this manner.
Is it possible to, may I see the ring? I would suggest we pass it to the jury. rather than the envelope, because the envelope may contain everything. All right, if you'll hand that to juror number 1, please. Can you retrieve that, please?
Just going to allow.
Yep. Ms. Clark.
Now, when you're at a crime scene, sir, you indicated earlier that you take notes of the crime scene, is that correct?
Yes.
Do you also, is it routine to have photographs taken at the crime scene?
Yes.
And what is the purpose of taking photographs at the crime scene?
To memorialize what is at a crime scene.
Is that another method of reporting what you find?
Yes.
With respect to the position in which items were found, or items that may have been moved from their original position, did you attempt to document that in photographs in this case?
That's correct.
And the photograph that shows the letter and the glove in their original position, you recall those photographs?
Yes.
Letter. Envelope.
And also,
Sustain.
the former use of the word original position, also conclusion.
Why don't you rephrase the question? It's compound. Assumes facts that aren't in evidence.
That's right. Do you recall being shown photographs of the envelope and the glove that were found at the feet of Ron Goldman, sir?
Yes.
And do you recall being shown photographs of those same items taken after the bodies were removed from the scene?
That's correct.
And did that, what did that accomplish, those two photographs?
The first photographs showed the evidence and the location that I first observed them. Second photographs showed those same items of evidence in a different position after the body of Mr. Goldman had been removed.
Ms. Clark, do you need the ring any longer?
I'm sorry?
Do you need the ring any
No,
longer?
we can put that away.
Perhaps we should have the detective replace the scrape. I'm concerned about the scrape envelope.
Put it back on. All right, now with respect to the videotape you were shown with the coroner's representatives in there and the photographer in there, tell us, in your experience, sir, 250 homicides, have you ever had a crime scene where the coroner investigators did not come in to remove the bodies?
Oral.
No.
Do you know of any other way of removing bodies from the crime scene other than to have the coroner's investigators step into it and remove them?
No.
And the photographer, have there been photographers at every crime scene you've ever investigated, sir?
Yes.
Oral.
Do you know of any way for the photographers to take photographs, accurate photographs of the evidence and where it was found without getting into the crime scene?
No.
Are these things, having photographers into the crime scene, the coroner's investigators in there, does this occur in every case, sir?
Yes,
Overruled.
it's a part of every investigation, yes.
Now, what dictates the manner in which you investigate a crime scene, the manner in which you document and collect evidence?
What dictates the manner?
Yes, what dictates what you do at a crime scene? Who you call in, when you call them in?
Vague. I want you to be a little more specific about what you're after.
Okay. Sir, can you tell us, first of all, do you conduct your investigation at every crime scene in the same way?
I've never conducted a crime scene investigation the same way,
And why is that?
because all homicide scenes are different.
And what do those differences have to do with the manner in which you conduct your investigation?
Depending on how many victims, how the victims are found, the type of evidence at the location itself are all factors in how you'd handle an investigation.
Okay. So the circumstances that you found at 875 South Bundy, did they in some manner dictate how you conducted the crime scene investigation in this case?
Certainly.
Can you give us some examples?
As to Bundy,
Yeah.
Bundy was a close-in crime scene. The victims were close to one another. The evidence was close to the victims. Determination was made, as one example, to remove the victims prior to the evidence because of this. If the evidence had been several feet away or out in the street or something else, perhaps the victims would have stayed at that location while the evidence was collected. You just have to deal with what you have.
And with respect to this particular crime scene, I'm sorry. Did the physical distance that you had to work with in terms of the location of the victims and their proximity to the evidence pose any particular problem?
Certainly.
And could you explain that?
The closeness of the victims to one another, the closeness of the victims to the evidence.
And what did that cause you to do in terms of your investigation?
As far as conducting the investigation,
As far as collecting the evidence, as far as calling in the criminalists, the print people, etc.
well, one was a determination that we would remove the victims prior to the evidence.
And why was that determination made?
Again,
I thought we've already asked and answered that.
All right, inside the house at 875 South Bundy, sir, can you tell us, first of all, did you notice any bloody shoe prints on the carpeting?
No.
Okay.
Overruled.
Okay, the fact that you did not find that, what did that mean to you?
It indicated to me that the suspect did not enter the location.
The knife on the counter, you had the photographer take pictures of that, you recall?
Yes.
On the kitchen counter. Did you make some determination as to whether or not you thought that was in some manner possibly related to the circumstances of the murder?
Not exactly. That's an agent just also covered on direct examination, not covered on improper redirect examination.
You know, it's been so long, I can't remember exactly. I thought we talked about on direct that there had been a determination that had tested negative for blood.
I remember that.
All
And
right.
I thought there was cross on it.
I don't believe so.
Okay, withdrawn.
All right. Did not appear to be nicked or damaged or in any way. No blood on it.
I remember that.
And where it belongs in the kitchen.
And, right. That's... Right, Your Honor, I have videotape and photographs that I'd like to show the detective at this time. This was a video shown to the defense yesterday, asked it to be marked People's next in order, People's 101.
People's 101. Yes, with the reporter, please. To you. I have not seen them yet. So we're going to take our recess for the afternoon at this time. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations or allow anybody to communicate with you with regard to the case. We'll see you bright and early tomorrow morning, 9 o'clock. All right, we'll stand in recess as far as the jury is concerned. As soon as the jury is cleared, we'll resume with 402 hearings regarding the videotapes. All right, don't go away. All right, back on the record. In the Simpson matter, all parties are again present. The jury is not present. Ms. Clark, do you want to show me this videotape?
Yes.
Do I have a feed problem with this tape?
No, no. proposed to show the video to the jury.
Well, let me just ask one other question. Mrs. Robertson, the hard copy photograph of that officer walking up the walkway, what defense number exhibit is that?
It's both. We have defense and people's. Was it people's 50-something, Deidre?
Well, when I said the hard copy, I meant not referring to Doug Rockne, just... $57? $57. All right, I don't show in my notes the 57 was used with regards to Detective Lange.
No, no.
All right. All right, I have the printout from the videotape, People's 57.
Yes.
And my notes indicate that it has not been shown to Detective Lange.
No, it was not shown to Detective Lange. I would have done it myself on direct, but we had not yet obtained the video at that time that I conducted direct, and of course that was quite some time ago. And during the cross-examination, we were able to obtain that tape, and we will be providing the cameraman's testimony who shot the tape, who can indicate, number one, that the film that the court has seen depicts the activities as they occurred in sequence, although there are portions of activities not shown in between. The crime scene tape was the first event that took place, the taking down of that tape. Subsequent to that, the officers walked into the scene, and subsequent to that, we have the officer walking up the walk, which is the photograph shown by the defense initially to Officer Risky, I think, and Detective Phillips. The people proposed to use this tape to put the photograph that has now been shown to the jury into context. The inference that has been drawn throughout the testimony of all of the the inference that the defense is seeking to have the jury draw from this photograph is that the crime scene was contaminated, was not maintained, and that evidence was destroyed as a result of the manner in which the investigation was conducted. The people seek to demonstrate that the photograph shown and utilized by the defense for that purpose was misleading and out of context. And what this tape does is demonstrate just that. It demonstrates that the crime scene tape was taken down, the investigation had been completed, and it was only after that point that we have the still shot, and this is a still taken from that tape, as the court can see. It was only after that point that we have the officer walking up the walkway in order to place it in context. Because the defense has proceeded with that theory with Detective Lange's testimony through cross-examination, attempted to demonstrate that, once again, it was shoddy work and it was sloppy work and they did not maintain the crime scene. It's relevant, the people submit, in rehabilitation for the work.
I understand the relevance of why you want to pursue this. That's not the issue. The issue is whether or not it's appropriate at this time on redirect examination of somebody who's not been shown this photograph on either direct or on cross. And just so the record's straight, this is also Defense Exhibit 1011 in smaller format.
Then, and in response to that, Your Honor, if the court feels that the general attack of cross-examination on Detective Lange and the manner in which the crime scene was handled is insufficient to provide a nexus for the redirect I propose to conduct with this still and with the video, we would simply ask the court, leave of the court to reopen direct. If I had the video at the time of direct examination, I would have sought to admit it at that time with this photograph.
I'll hear from the defense.
The court has correctly pointed out that we never asked Detective Lange any questions regarding this. In fact, the only question the court allowed us to ask was, I think, with Risky some officers ago, whether or not he could recognize that particular officer. That's the only thing.
Because we had no foundation.
That's correct.
For the tape.
And that's all that you were allowed us to ask. We never asked this detective Lange about that at all. In fact,
now that I've seen the videotape, I'm very happy with that decision.
Perhaps it was the right decision, Your Honor. But from the standpoint of what happened, I think that this is not the witness, as we've heard so many times with regard to, not the time with regard to that video. At the appropriate time, if they can lay a foundation, then so be it. I mean, there are a lot of other things in that video also. But I think the point is, counsel talks about that scene being traipsed about, or our contention regarding that. We've demonstrated that with our own video of what took place contemporaneously with that, which they've asked questions about appropriately. And that's the way to go about redirect examination. Although we did see some cross-examination of that witness today also. But it seems to me that this was not appropriate at this point, and that's the point I was trying to make at sidebar, Your Honor.
Okay. Thank you, counsel.
Thank you. Your Honor, on another matter, something else I wanted to bring up after you rule on this.
Ms. Clark,
Okay.
have you provided a copy of this videotape to the defense?
I believe we did.
No, we saw
Yes,
it.
we did. We gave him copy.
We saw it yesterday.
All right.
Your Honor, what concerns me is that no matter what purpose the court limited to, the court knows that it's very graphic evidence. And showing the jury that photograph did, I'm sure, accomplish the very purpose for which Mr. Cochran introduced it. He showed it to the jury, giving them the impression that despite the officer's testimony that care was taken to not contaminate, not destroy evidence, that in fact it did occur. And now Mr. Cochran's afraid that the jury's going to see this tape and realize they've been sandbagged. That's why Mr. Cochran's objecting, because otherwise he shouldn't. What he did was he took a photograph out of context and used it in very graphic manner to demonstrate something that was a complete falsehood.
Ms. Clark, forgive me for interrupting you at this point, but the issue really is, do I give you permission to reopen? That's the only question that I have to address at this point. Whether or not somebody's being sandbagged or it's misleading, that's argument for the jury. It's of great interest to me in an abstract sense, but what I need to determine is whether or not I should allow you to reopen, since we all agree now that neither of these two were used with regards to this witness, correct?
Yes, of course, we do agree that,
All right.
Your Honor. I just wanted to ask the court to consider also
that's
that...
the only issue.
Would the court consider also the fact that when there's been impeachment in such a broad manner, on so many fronts in so many ways, all focused towards the demonstration of one thing, which is bad crime scene handling, that rehabilitation in this manner, in a general manner, to demonstrate that the focus of the attack has not been shown, that there has been some misleading indications by the defense in allowing Detective Lange to explain that, yes, people do get into crime scenes, and yes, ultimately the tape is taken down in response to the general impeachment that it has gone on with respect to specific categories, but the general theme. I mean, just because the impeachment didn't specifically go to that picture, I don't think that necessarily precludes us from using the picture and the videotape to rehabilitate the manner in which the crime scene has been handled by the LAPD. That's a sub-argument.
May I give some response, right? Some response to that sub-argument.
Well, the real issue is, do I allow the prosecution to reopen to use this piece of evidence? That's the only real issue.
And that's the point. All this other posturing and something about misleading, Your Honor, that's preposterous. All we've done is you allowed us to show the photograph to see if they recognize this person. We didn't know when that photograph was taken. There's all kind of representation. It was taken on the 15th. We know that's not true now. It was on the 13th.
I never made such a...
Just a moment, Your Honor. May I conclude? With regard to this, counsel likes to make all these big speeches all the time. All we want to do is ask, Your Honor. They're asking to reopen. This was not with this witness, and all I've said, it wasn't with this witness. And that's the issue here. They can bring it up, they can use it with Van Adder, Your Honor. She wants to do it with the other officer. It's not us trying to hide all the witnesses, Furman, Van Adder, and Golden. We're not trying to do that. So the question about who's hiding. So the point is, Your Honor, is to make that decision, and we'll submit it.
All right.
Talk about speeches. Where did Furman and Van Adder come into this? You know, counsel's amazing. I've never said June 15th. I've never said anything about this. I've always said the same thing, that the photograph was taken out of context, and now we can prove it's true, and that's what hurts Mr. Cochran. But it is the truth, and that's what we've got. The problem is that Detective Lange is the one who handled Bundy, not Detective Van Adder.
All right. Thank you, counsel. All right. Motion to reopen is granted. All right. We'll resume with our DNA issues.
A couple other issues so that someone's confused.
Sure.
The court had asked us to point out to the court with regard to the issue of the internal affairs investigation.
Yes.
I indicated to the court, just out of an abundance of precaution, because of Your Honor's spouse's occupation, I guess, after the first of this year. I thought the record should be made clear with regard to her involvement or lack of involvement with regard to these issues that have been raised on Mark Furman today. And I indicated to the court we would do that, and the court suggested we should do that.
Right. My understanding is my wife has no connection with this investigation regarding Detective Furman.
Very well. Thank you for the representation, Your Honor.
All right. Thank you, Mr. Cochran. All right. I was going to get a report from Mr. Hodgman and from Mr. Scheck regarding our status on microscopes and...
Well, I can report that I was asking Ms. Robertson whether a fax had come through. I know that Mr. Morton has located a laboratory that apparently has been upgraded of a criminalist named Carol Hunter, who I understand is in this area. And that he's checked with her. He believes she has the appropriate equipment. He's made arrangements. We've made arrangements to rent that laboratory Monday, Tuesday, Wednesday of next week to examine the trace evidence. And I had asked him to write a letter to the court.
Could we have it quiet in the courtroom, please?
Your Honor, sorry to interrupt the counsel, but Mr. Hodgman needs to be here to speak on this issue.
You asked for a report on.
All right. Well, I thought he was going to be here. Yeah, it'd be...
Well, in any event, Your Honor, just to make it clear, he's going to, I was hoping the letter would be faxed. I will have it faxed either by 5 o'clock to the court and to the prosecution the first thing in the morning, but I'm sure that's the nature of the arrangement, and I can notify Mr. Hodgman of that.
All right.
And I think that...
Ms. Lewis, would you get me an ETA for Mr. Hodgman, please?
I'm doing that right now.
All right, counsel, do you think there's anything else we need to put on the record as far as that's concerned?
As far as that's concerned?
Yeah, I mean, I'll keep a court reporter around if you want.
No, I thought there was something with respect to the fingernail scrapings. I have an application with respect
yes.
to that.
Mr. Harmon, what's the latest on that? Good afternoon, sir.
Hi, Your Honor. When we're done with this, I'd like to get on the record.
Ms. Clark, do me a huge favor and stick around for this.
47, 50, and 78. As you know, I've been striving to get to the bottom of that for some weeks now. The fingernail scraping material is very simple, Your Honor. And Dr. Blake, I'm surprised he hasn't passed this on to the defense. Dr. Blake viewed the results of the DOJ typing of D1S80 on 3 of the scraping items.
Your Honor, I would object to this. I think the only question is whether or not a report has been produced.
Excuse me, Mr. Scheck, please. Don't interrupt counsel.
My objection, Your Honor, is that if he's going to start announcing results in court before we've had a chance to see them, before they've been submitted to Your Honor,
Well, he was about to... Mr.
Scheck.
Mr. Scheck, have a seat, please. Thank you.
Thank you, Your Honor. At the completion of those tests, when we knew where the results were heading, we notified the court and counsel on February 16th that we were sending the extracted DNA from those items to Cellmark, and Mr. Clark is handling Cellmark, and he'd be glad to fill you in on that. But
all right, what about these? What about this preliminary result that's been communicated to Ms. Clark?
do you want to know what it is? I mean, it's no surprise. They're consistent with Ms. Brown. It's just her blood under her fingernails,
Right.
contrary to what Mr. Cochran said in his opening statement.
Has there been a report filed with the court yet?
No, Your Honor.
When should I anticipate that?
I wish I could tell you. They're still doing, you know, I don't want to name all the other things they're doing again, but there's still a lot of other things that they're doing that are providing probative answers in this case. So at the pace that the trial is going, we're hoping that they finish everything so that they can write one more report. As you know, they wrote a very lengthy report. Once they start the report writing process, they can't do any more work. So I had tried to mention this a couple of weeks ago. It may be that because Mr. Simpson insists on his right to a speedy trial, that there will be no time to write a final report. And this is why Dr. Blake, going over there, photographing everything, seeing everything as it's unpacked, spending hours there, it shouldn't surprise anybody, but he probably won't be a witness in this courtroom. But he's seen all this stuff as it's unfolded in there. So there is no report. I can't tell you when one will be available, but the defense has had an opportunity to view these things as they're unpacked, to take their own photographs of these things, to take photographs of the results. He's there whenever he wants to be there. I think he's there a couple of times a week at least.
All right, Mr. Clark, you want to tell me about the status at Cellmark?
Surely, Your Honor. That testing is completed on the items that Mr. Harmon just described. Their report will be in the court's hands no later than Friday, most likely before Friday.
All right, this is the polymarker?
Correct. Six
PCR.
total, 6 genetic markers in total with regard to the fingernails.
All right, and that's already been verbally communicated?
Correct.
All right, Mr. Scheck. Well, we have to have a discovery issue here.
Your Honor, first of all, as a discovery matter, it seems to me highly improper for the prosecutor to be able to attempt to elicit, intentionally elicit, through this witness, testimony, A, that he's incompetent to reveal to the jury, and I'll explain why and how severely prejudiced we are by that, his testifying to this effect. He is not an expert on DNA. He is not an expert on genetic marker systems, and he's not an expert in, he has no personal knowledge as to how these tests were conducted, and that will be significant as this trial unfolds. Prosecution knows that, intentionally tried to elicit that evidence through this witness, knowing all of that. Number two, they intentionally elicited this testimony through this witness without giving us a report by their own admission. No report was given to the court, and no report was given to the defense. I would note that the process that Mr. Harmon, because he's apparently in charge of the Department of Justice testing in this matter, is pursuing, I think is contrary to the court's initial instructions as to how test results were supposed to be communicated. That is, his purposeful practice is to allow the Department of Justice to test significant items, such as the fingernails. They get results, but they don't send a report about those results. Instead, they're waiting until they finish all testing on various other kinds of items, and then at some point down the line, probably in the middle of his testimony from Mr. Simpson from the Department of Justice, then they'll give us a report. Now, that is contrary to the understanding I had as to how we were proceeding with the evidence in this case. That is, from the moment of the split hearing on forward, this court wanted to know what results were obtained by the lab with respect to specific items of evidence as soon as possible, because we were in this very unusual position that the prosecution is allowed to test whenever they want, in whatever process they want, at whatever speed they want, items of evidence in this case to time it to get a strategic advantage. And this is an example of exactly what they're trying to do. Now, Dr. Blake has communicated to me something about the fingernail scrapings with respect to how they were packaged and how this evidence is coming in. And I want to give the court a preview, and I think the court's already seen some of this with respect to this evidence. What we have, first of all, is a genetic marker test performed by Mr. Matheson of the LAPD of fingernail scrapings from 1 of 10 nails, I suppose, or maybe more than 1 of 10 nails. We don't know. We'll have to hear from him. There's nothing in the records to indicate which nails he scraped and what blood he took from which hand. That will be important, because there's no question that blood was under the nails of Nicole Brown Simpson, and some of that would undoubtedly be her blood. But as to which scraping from which nail might have revealed genetic material from another person with whom she was struggling is going to be a key issue in this case. They issued a report. Mr. Matheson issued a report saying that fingernail scrapings from some nail, we don't know which, or maybe more than 1 nail, came back on the EAP system as a B. In his report, he indicates that that excludes Nicole Brown Simpson, O.J. Simpson, and Ronald Goldman. There is a qualifier there that says, well, of course, if this was degraded, then maybe we can't test this result. Now, that's an issue that's going to be litigated with experts from both sides as to whether that's a real bee or not, whether that's genetic material from somebody else under her nails or not. And the prosecution knows that very well, and everybody knows that very well, that that debate is coming. That's evidence of innocence. It comes out of their laboratory. The truth of the matter is, and they know it well, A, DNA test results from other nails that may be, have genetic markers that may have the genotype of Nicole Brown Simpson, it's, you know, and would be expressed as some statistical estimate as to how rare that is, but some blood from some nail that may be hers is not necessarily relevant to this issue, number one. And number two, it is, of course, possible, more than possible, it is a scientific fact that it's possible for another individual who is not Nicole Brown Simpson to have an EAB genetic marker of B, hers is AB, and have a DNA marker that is the same as Nicole Brown Simpson's. So both of those issues are to be litigated and obtained. The prosecution knows that full well. What happened here is they, in violation of our discovery rules, in an attempt to gain a strategic advantage, purposely asked a question of the witness that was obviously beyond the witness's personal knowledge and expertise in order to bring that out before this jury. That was wrong. That is in bad faith, and we should get a curative instruction. The curative instruction that I would propose we draft carefully for the court's consideration for tomorrow would have to do to instructing this jury. It was improper to ask that question of this witness. Certainly, it was part and parcel of trying to take advantage of failure to turn over results in a timely fashion to the defense, and that it was misleading to the jury, and they should await the testimony of the proper witnesses to consider that evidence.
May I briefly, before Mr. Harmon turn on the technical issues concerning this matter? The Board is aware of the opening statement given by Mr. Cochran in which he misleadingly told this jury that blood marker EAP tested out to a B, which was inconsistent, and then highlighted a half a paragraph of the expert's work. The balance of the half paragraph that was never shown to the jury indicated clearly that this was not necessarily inconsistent with Nicole for the reasons that the court is aware of the manner in which the BA type degrades. Mr. Cochran never told them that. Mr. Cochran, however, should have been aware of the fact that DNA testing was ongoing for those nail scrapings. He chose to stand up before this jury and give an opening statement based on half a loaf. He misled the jury as to what he did know and didn't tell the jury that there was other testing going on and took the risk that that testing would absolutely refute everything he said. And he's now going to suffer for that risk taken because the DNA testing has panned out exactly as expected. Of course, it's the blood under her fingernails. The people have done nothing wrong in eliciting from this detective on a totally separate issue the manner in which he conducted his investigation. The results have not been communicated to the jury through that witness, Your Honor. The only thing the detective testified to, as best I can recall, is that he was aware of those results and it did not cause him to change the focus of his investigation. That's an oblique reference. Nevertheless, it went towards the same avenue of testimony, which was in response to the cross-examination on that very same topic. But for counsel to get up and call this misconduct when their own expert knows very well what the results are because he's standing right over their shoulders watching them do the testing is absurd. If they don't communicate with their own expert, the people can't help them. You know, if they don't want to call the guy and ask what happened with this or what happened with that, if I was them, I would. Something like this where I stood up in front of the jury and made promises that I know might never be delivered, in fact, might come back to slap me in the face, I would be calling daily to find out what those results are. Counsel hasn't done that. I mean, that's the way he chooses to conduct his defense. That's fine. That's for him to choose. But to turn around and blame the people because testing that was ongoing at the time he made the representations and chose not to take into account in his opening statement have now come to fruition in the purview of knowledge of his expert is nothing to blame the people for. I don't see why the phone call wasn't made between them, but that's not something I can control.
But in terms of fairness and discovery procedure, though, I agree that the The question to Detective Lange was rather oblique. Knowing that certain testing was done of the nail scrapings in Nicole Brown Simpson, and knowing the results of those tests, did that cause you to change the focus of your investigation? Pretty indirect way of saying those things. But it does, the kicker there, though, is that you said your question was knowing DNA results, which Mr. Cochran had said a lesser test had been used during his opening statement. So they're different things. And the question is whether, as a matter of discovery and fairness, you should be able to elicit from witnesses testimony regarding items that we have not gotten the reports back on regarding the test results. That's the issue.
Yeah, and I asked him about, I think I even confined it more narrowly to DOJ. Did I just say DNA? I can't remember. DNA?
Excuse me, counsel. My notes say DNA.
I defer to the court's memory, then mine is certainly not at its highest peak today especially, but I confined it, and I stated it that way because I know that Ed Blake, their expert, is standing and watching the testing.
All right, well, let's put the shoe on the other foot. Let's assume they're asking the questions and they get a similar question and answer without having turned over the report yet.
But if my expert is standing there and knows the result, I don't think I have anything to complain about. I don't think it's any different. They have their expert standing there watching the testing going on, fully aware of what the results are, and now they're blaming us because they haven't communicated with him? I mean, that seems to me ridiculous. They certainly should have a system set up where they are communicating about what the results are, and that's why I thought there was no discovery issue with respect to this, because I know he's there privy to the results moment by moment as they come out. So how can this possibly be?
I'm having to make that assumption. You're asking me to make an assumption that Mr. Blake is aware of this and has communicated with defense counsel. You're asking me to make that assumption.
No, that's not an assumption. I think that the procedures put into place by this court with respect to testing at DOJ were that Ed Blake had to be notified and be present for all testing conducted.
He has to have access and he can watch it, but that doesn't necessarily mean that he knows what the results are.
How could he not? May I allow Mr. Harmon to address this aspect?
In any event, that's the issue. You're asking me to assume something.
Yeah, and I think that it's a fair assumption to make, and I think Mr. Harmon can better address this issue. But I will tell the court this. I asked the question in good faith, believing that the defense had to know of the result by definition if I knew of the result. But knowing that their expert had to be present for all testing, and that has slowed us down, by the way, immeasurably, knowing that he has to be present for all the testing.
All right, Ms. Clark, my inclination is to instruct the jury to ignore that question and answer.
Would the court hear from Mr. Harmon at this time? There may be some...
But Ms. Clark, it's really a discovery issue. If we don't have a report that's been communicated to the court and then officially turned over to the defense, is it really fair for you to be asking questions about it at this point? Because in all likelihood, if the results are as you say, you'll be able to present that information to the jury at a later time, but to have done that through Detective Lange was probably not a fair way to do it at this point.
But that's what I'm trying to indicate to the court, is that the people I was acting in good faith.
I understand you're acting in good faith. I'm not questioning that. You had the information, and you believe that the other side also had that information.
Right.
That may or may not be true. You're asking me to make an assumption that Dr. Blake knows this and has communicated it with Mr. Scheck and Mr. Douglas. I don't know that.
Well, let me ask the court this. If Dr. Blake does in fact know the result, then where do the discovery obligations lie at that point? Once their expert knows, what are the people's obligations with respect to compelling him to tell them what the result is?
But our agreement has been that all labs doing testing communicate the results to me. And then I did, because of our leak problems, and then I disseminate those results to the parties, which has gone just fine.
It's been going well.
Because there have been no leaks since the first SOX incident.
Which has been good, but I really, please, may I ask the court to hear from Mr. Harmon on this? He does have
how is Mr. Harmon's comments going to change my view that our agreement was to have these things communicated to the court first? Mr. Harmon?
May I let him?
Be brief.
I always have been, Your Honor. I wasn't here when this arrangement was set up. I understand the results were supposed to go to the court.
And they have. They've been...
As they have. What you don't realize is when I'm not here on Fridays, I'm up at the DOJ lab looking at things they're doing. And I'm seeing results. And I'm doing that so I can